Members of the jury, you are considering the case of the State of Georgia versus Chloe Alexis Driver. The grand jury has indicted the defendant with 1 count of malice murder, 2 counts of felony murder, 1 count of aggravated assault, and 1 count of cruelty to children in the first degree. The indictment reads as follows. In the Superior Court of Cherokee County, the grand jurors selected, chosen, and sworn for the County of Cherokee, and they are named in count 1, in the name and behalf of the citizens of the state of Georgia, charge and accuse Chloe Alexis Driver with the offense of malice murder. For that the said accused on or about the 8th day of December 2020 in Cherokee County, Georgia, did then and there unlawfully, with malice aforethought, cause the death of Hannah Nicole Driver, a human being, by stabbing Hannah Nicole Driver in the neck with a knife, contrary to the laws of this state, the good order, peace, and dignity thereof. In count 2, the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Chloe Alexis Driver with the offense of murder. For that the said accused on or about the 8th day of December 2020 in Cherokee County, Georgia, did then and there, while in the commission of the offense of aggravated assault, a felony as alleged in count 4 of this indictment, caused the death of Hannah Nicole Driver, a human being, by stabbing Hannah Nicole Driver in the neck with a knife, contrary to the laws of this state, the good order, peace, and dignity thereof. In count 3, the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Chloe Alexis Driver with the offense of felony murder. For that the said accused, on or about the 8th day of December 2020 in Cherokee County, Georgia, did then and there, while in the commission of the offense of cruelty to children in the first degree, a felony as alleged in count 5 of this indictment, caused the death of Hannah Nicole Driver, a human being, by stabbing Hannah Nicole Driver in the neck with a knife, contrary to the laws of this state, the good order, peace, and dignity thereof. And in count 5, the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Chloe Alexis Driver with the offense of cruelty to children in the first degree. For that the said accused, on or about the 8th day of December 2020 in Cherokee County, Georgia, did then and there maliciously cause Hannah Nicole Driver, a child under the age of 18 years, cruel and excessive physical and mental pain by stabbing Hannah Nicole Driver in the neck with a knife, contrary to the laws of this state, the good order, peace, and dignity thereof. It has been filed on behalf of Shannon Wallace, the elected district attorney, on March 8, 2021. The defendant has entered a plea of not guilty to this indictment. The indictment and plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime charged is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you should acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. I will interject here that this is not a gender-specific charge, and sometimes I'll be saying he and sometimes I'll be saying she, but I am referring to the defendant, Ms. Driver, in this case in these instructions. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based on evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and the exhibits admitted during trial. Evidence also includes stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court. It does not include the indictment, the plea of not guilty, opening statements or closing arguments by the lawyers, or questions asked by the lawyers. The parties have entered into a stipulation that has been approved by the court. When parties stipulate facts, this is in the nature of evidence. You must take that fact or those facts as a given without the necessity of further proof. You make all decisions based on the evidence in this case. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as by personally observing or otherwise witnessing that fact. Circumstantial evidence is a proof of set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility or believability of the witnesses. In deciding credibility, you may consider all of the facts and circumstances of the case, the manner in which the witnesses testify, their intelligence, their means and opportunity for knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the case, and their personal credibility as you observe it. Testimony has been given by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based on that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of her constitutional rights. To be voluntary, a statement must be freely and willingly given without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. In determining voluntariness, you may also consider to what extent the defendant was informed of her rights as discussed below. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of her constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement officers are as follows. The defendant had a right to remain silent. If the defendant chose not to remain silent, anything she said could be used as evidence against the defendant in court. The defendant had a right to consult a lawyer before any questioning and to have the lawyer present with her at all times during any questions. And if the defendant did not have money for a lawyer would have been provided for her to represent her before any questioning and to be present with her during any questioning. The burden of proof is upon the state to establish that the warnings of all rights mentioned were given, that they were understood and knowingly given up by the defendant. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find defendant was properly informed of these rights and that she understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict. You should consider with great care and caution the evidence of any out-of-court statement allegedly made by the defendant, offered by the state. The jury may believe any such statement in whole or in part, believing that which you find to be true and rejecting that which you find to be untrue. You alone have the duty to apply the general rules for testing the believability of witnesses and to decide what weight should be given to all or any part of such evidence. A defendant's out-of-court statement that is not supported by any other evidence is not sufficient to justify a conviction, even if you believe the unsupported statement. However, proof by other evidence beyond a reasonable doubt that the crime alleged has been committed may constitute supporting evidence of a defendant's statement, if any, should you so find. The law does not fix the amount of supporting evidence necessary. You must determine whether or not other evidence sufficiently supports a defendant's statement so as to justify conviction. If you find that there was a statement made by the defendant that was supported by other evidence, the degree of proof necessary to convict is that you be satisfied of the guilt of the defendant beyond any reasonable doubt. Evidence relating to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as has been given to you. As opinion testimony, evidence relating to DNA comparison is dependent upon many factors. Among the factors are the credibility and accuracy of the witnesses who were involved with the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves used to form such opinions. All of these issues are matters for you to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparison in your decision in this case. The defendant is charged with crimes against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. This defendant will not be presumed to have acted with criminal intent, but you may find such intention, or the absence of it, upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within the discretion of the jury. The law provides that criminal actions shall be indicted in the county in which the crime was allegedly committed. Venue, that is, whether a crime, if committed, was committed in Cherokee County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any other element of the offense. Venue must be proved by direct or circumstantial evidence, or both. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice where there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act and moved the defendant to do the act, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or the lack of it. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Count 2 of the indictment alleges the commission of felony murder based on the alleged commission of aggravated assault. Count 3 alleges the commission of felony murder based on the alleged commission of cruelty to children in the first degree. Aggravated assault and cruelty to children in the first degree are felonies, and I will define them for you shortly. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault or the felony of cruelty to children in the first degree, as alleged in this indictment, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was committed or attempted. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. For aggravated assault, the state must prove that the defendant assaulted another person with an offensive weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. In deciding whether a knife is an offensive weapon, you may consider all of the following factors: the nature and extent of any injury inflicted, the character and capabilities of the weapon, the manner in which it was used, any display of it to the jury, and any other circumstances of the case. For cruelty to children in the first degree, the state must prove that the defendant maliciously caused cruel or excessive physical or mental pain to a child under the age of 18. In deciding whether the defendant acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the pain without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that pain may result. The act of committing suicide is not unlawful in Georgia. Only the act of assisting another person's effort to commit suicide is unlawful in Georgia. Every person is presumed to be of sound mind and discretion. However, this presumption may be rebutted. If you find that at the time of the alleged criminal act, the defendant was suffering from insanity or mental illness, then you shall determine whether the defendant is not guilty by reason of insanity, guilty beyond a reasonable doubt, or guilty beyond a reasonable doubt but mentally ill. The law makes a distinction between being insane at the time of the commission of the alleged criminal act and being mentally ill at the time of the alleged act. Therefore, it is necessary for you to understand this distinction. A person shall be found not guilty of a crime if at the time of the act constituting the crime, that person did not have the mental capacity to distinguish between right and wrong in relation to the act. In regard to the question of sanity or insanity at the time of the alleged criminal act, there is a test to determine whether the person is suffering such a degree of insanity that the person is not capable of committing a crime. The test is whether the insanity was such that it deprived that person of the mental capacity to distinguish between right and wrong in relation to the act that the person allegedly committed. The perpetrator may be what is commonly referred to as insane in a loose and general sense, yet in the eyes of the law, she may be sane and responsible so far as the act in question is concerned, if at the time of the commission of the alleged act, the accused had sufficient capacity to distinguish between the right and wrong of the particular act. This is a question of fact to be determined by you, the jury. Mere weak-mindedness, mental abnormality, or mental state shown only by repeated unlawful or antisocial conduct, which does not amount to insanity, is not a defense to a crime if the person had the mental capacity to distinguish between right and wrong in relation to the alleged offense when the alleged offense was committed. Insanity may be only a temporary malady, and if the accused did not have sufficient mental capacity to distinguish between right and wrong with reference to the act alleged in this indictment at the time that the act was committed, then the accused would not be criminally responsible. The test of criminal responsibility is the condition of the mind of the accused at the time of the commission of the alleged act. If a person of unsound mind has intervals of understanding during which that person can distinguish between right and wrong of a particular act, then that person shall answer for that act if it was committed during those periods of understanding. If, due to an affliction of the mind, a person's mind is so impaired that the person is incapable of forming the intent to commit the act with which she is charged, or to understand that a certain consequence would likely result from the act, then that person would not be criminally responsible for the act. The defendant has the burden of proving insanity by a preponderance of the evidence. If you believe beyond a reasonable doubt that the defendant committed the act charged in this bill of indictment, but also believe by a preponderance of the evidence that at the time of the commission of this act, the defendant was mentally incapable of distinguishing between right and wrong regarding this act, then it would be your duty to acquit the defendant because of insanity. I have already defined for you what beyond a reasonable doubt means. Now I will define for you what a preponderance of evidence means. It means evidence on the issues involved that is sufficient to incline a reasonable and impartial mind to one side of the issue rather than to the other. Proof by a preponderance simply requires that the evidence show that something is more likely true than not. If you find the defendant not guilty by reason of insanity, then you must specify this in your verdict, and your deliberations cease. In that event, the form of your verdict would be, we the jury find the defendant not guilty by reason of insanity. Should you find the defendant not guilty by reason of insanity at the time of the crime, the defendant will be committed to a state mental health facility until such time, if ever, the court is satisfied that she should be released pursuant to law. There is an exception to the rule that I have just given you. If a person has sufficient reason to distinguish between right and wrong as to a particular act about to be committed, but because of some mental delusion, the person's will was overpowered so that there was no criminal intent to commit the act in question, that person cannot be held criminally responsible for that act. In that regard, a person shall not be found guilty of a crime when, at the time of the act constituting the crime, that person, because of mental disease, acted because of a delusional compulsion that overpowered the person's will to resist committing the crime. In order for mental delusion or delusional compulsion to constitute a defense, it must appear not only that the accused was actually laboring under a delusion at the time of the commission of the alleged criminal act, but that the alleged criminal act itself was connected with the particular delusion under which the accused was then laboring, and that delusion was as to a fact that, if true, would have justified the alleged act by the accused. This is a question of fact to be determined by you, the jury. Justification is defined as follows. Sometimes a defendant's threat or use of force is legally justified, and so is not a crime. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury when she reasonably believes that the use of such force is necessary to prevent death or serious bodily injury to herself or a third person. The state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you decide the defendant's actions were justified, then it would be your duty to find the defendant not guilty. Reasonable beliefs are explained as follows. For the defendant's use of force to be justified, the defendant must believe that her use of force is necessary. That belief must be reasonable. That is, a reasonable person would also believe that the use of force is necessary, and the defendant's reasonable belief must be what prompts her to use force. Evidence of acts of violence against the defendant perpetrated by a third party have been admitted into evidence. If you find from the evidence that the defendant suffers from battered person syndrome, you may consider such acts to the extent that they relate to your assessment of the mental state of the defendant at the time of the commission of the offense. If you believe this defendant committed the act charged in this bill of indictment, but at the time the defendant was actually laboring under a mental delusion and that act was connected with that delusion, then you should find the defendant not guilty because of insanity. In this event, your deliberations will cease, and the form of your verdict would be, we, the jury, find the defendant not guilty by reason of insanity. I charge you that if you should find the defendant not guilty by reason of insanity at the time of the crime, the defendant will be committed to a state mental health facility until such time, if ever, that the court is satisfied that she should be released pursuant to law. If, and only if, you do not find the defendant not guilty by reason of insanity, then you may consider whether or not the defendant was mentally ill. As to being mentally ill at the time of the act alleged in the indictment, the term mentally ill means having a disorder of thought or mood that significantly impairs judgment, behavior, capacity to recognize reality, or ability to cope with the ordinary demands of life. The term mentally ill does not include a mental state shown only by repeated unlawful or antisocial conduct. Under the evidence in the court's instructions, if you find and believe beyond a reasonable doubt that the defendant is guilty and was mentally ill at the time of the commission of the offense, then you would be authorized to find the defendant guilty but mentally ill at the time of the crime. If this is your finding, then you must specify it in your verdict, and the form of your verdict in that event would be, we, the jury, find the defendant guilty but mentally ill at the time of the crime. I charge you that should you find the defendant guilty but mentally ill at the time of the crime, the defendant would be placed in the custody of the Department of Corrections, which will have responsibility for the evaluation and treatment of the mental health needs of the defendant, which may include, at the discretion of the Department of Corrections, referral for temporary hospitalization at a facility operated by the Department of Behavioral Health and Developmental Disabilities. Any evidence as to the insanity of the defendant is to be considered by you along with all of the other evidence in this case. If the evidence as a whole raises a reasonable doubt as to the defendant's guilt, that doubt must be resolved in favor of the accused. I think you're going to have, if you would help me out with the verdict form. You can see, you will have the verdict form with you in the jury room, but as you will see, you have all your choices laid out for you as to each count, and you should follow the directions that I've just given you as to how you make those determinations. If after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Cherokee County, Georgia, did commit the offense as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty, or if you have any reasonable doubt as to the defendant's guilt, then it will be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. Those two options are options A and C on the verdict form. And then I have also explained to you the law as it pertains to your options B and D on the verdict form. Whatever your verdict is, it must be unanimous. That is agreed to by all of you. One of your first duties in the jury room will be to select one of your number to act as foreperson, who will preside over your deliberations, and who will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an honest opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of other jurors. By no ruling or comment that the court has made during the progress of the trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon whether the defendant is guilty or not guilty. You are only concerned with determining whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. Your verdict should be a true verdict based upon your opinion of the evidence according to the law as given you in this charge. You are not to show favor or sympathy to one party or another. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. As I said, your verdict, whatever it is, must be unanimous. It must be in writing. It must be signed by one of your members as foreperson, dated, and returned to be published in open court. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a cell phone, laptop, tablet, or computer, to communicate to anyone any information about this case, to receive any information about this case, to conduct any research about this case, or for any reason until I accept your verdict. We do have 3 alternates, and those are numbers and 201, and we will ask that you remain right outside the door there, and we'll call you back in for some further instructions. Now, all the rest of you may retire to the jury room. Do not begin your deliberations until all of you are present, till you have received the indictment, a copy of these jury instructions, and all of the evidence in the case. So you may be excused. What you've already noted.
I will say that I think the court worded some of it out of the order that we have it in the document, but I think it was all.
Sometimes pages stick together. Okay. I've got the indictment with the witness list torn off. I have the charge. I have the verdict form. Have y'all agreed on what evidence is going out?
I just need to go, if I can be excused, Judge, to the indigent defense office. We're going to try to print that extra picture off and
Okay.
add it to the.
In the meantime, is there any objection to the alternates being excused, subject to being called?
No.
All right, we'll bring in 108, 94, and 201. Anybody have nothing to watch them on?
We just leave those.
Leave them
here.
here. Well, if you just want to review that. All right, 108, if you'll raise your hand. Okay, 94 and 201. All right. Sometimes I say that being an alternate juror is like being first runner-up in a beauty pageant. You don't get to serve unless somebody ahead of you is disqualified. So we don't ask you to remain with us. We will let you be excused if you can give the bailiffs a phone number where they can reach you, and you could be back here within a half hour. Don't get further away from us than that, because we would need you to return to us if anything happened to any of the other jurors before a verdict is arrived at in this case. So if you can do that, we will let you be excused. You will be excused subject to all the same directions that I've been giving you throughout the trial about not reading any media reports, doing any research, having any conversations with anybody, but you can be at least a little more at leisure as we excuse you. We will tell you when the verdict has been reached and when you are finally excused from your service. We appreciate your cooperation and your service in this case. But you can step out and give the bailiff your phone numbers, and we will let you know as things transpire.